Good evening, everyone. It's my pleasure today to welcome you and the speakers for this March webinar organized by social scientists against the hostile environment. I am Marie Godin from the University of Oxford, and I'm co-chairing this webinar with my colleague, Michaela Benson from Goldsmiths University. Today's webinar is entitled Brexit, Citizens' Rights and the Hostile Environment, Uneven Stakes, Unheard Voices and Unresolved Issues Beyond the Headlines. And the organizing group for this webinar included Don Flynn, Nando Sigona, Georgia Donna, Michaela Benson, and myself. This event is recorded and will be available online on the Social Scientists Against the Hostile Environment website shortly after today, alongside all the previous webinars that took place over the last few months. And I invite everyone to have a look at it. For today's webinar, we have four wonderful speakers, Claudia Bernard from Goldsmiths University and Ayola Salanke from University of Leeds. They will be speaking about the impact of the hostile environment on child citizens and looking at the case of some Zambrano carers. Then we will have Brian Dickoff from Migrant Organize, who will be speaking on the EU Settled Status Scheme and EEA citizens living with mental health issues. And then we will have Mihai Bica from the Roma Support Group, who will be speaking on the EU Settled Status Scheme and the hostile environment and the Roma. So I will be introducing all the speakers before their talk, which will be around 15 to 20 minutes each. And after the three interventions, we will have a Q&A. And I invite you not to wait until the end to write the questions that you may have for each of the speaker. And you can write them down in the chat. So Michaela Benson will be the one reading the questions in the chat, and she will also be the one leading the discussion afterwards. But before I actually introduce the first speaker, I'm going to just say a few words about the webinar and the rationale behind it. So this webinar aims to open up the conversation about Brexit and citizens' rights and aims to move beyond the headlines and the loud voices of the citizens' rights campaigns to demonstrate how it failed to consider some of those most deeply impacted by Brexit. In this way, the webinar, through a series of critical interventions, will reveal how the negotiations and implementations of citizens' rights are deeply rooted in the hostile environment, expanding the racialized, classed, ableist, and gendered exclusions at its core. There is no doubt that the lives of EU citizens in Britain have changed since the referendum, with the emergence of new hierarchies of inclusion into and exclusion from citizenship in rebordering Britain. However, the relatively privileged legal terms on which most EU citizens were able to live in the UK prior to Brexit, paired with assumptions that free movement was unconditional and gave limitless access to welfare, has led to limited awareness of the extent to which, even before Brexit, experiences of living in the UK and of its border regime were uneven, playing out along known lines of inequality within this population. For example, deportations and detentions of EU citizens had been on the rise, particularly among homeless people as well as among migrant Roma communities. Similarly, with the end of free movement, the government has designed a system to allow EU citizens and their family members who are already living in the UK to retain their residence rights through the EU settlement scheme. And it's not rare to read in the news that it has been a huge success. However, still for a significant number of people, especially those facing already social exclusion, applying to the scheme is still an issue. And today, more than ever, there is a growing fear that those who will miss the June cutoff date will become undocumented, at risk of being detained and removed. In fact, Brexit, the negotiations and the implementation of the withdrawal agreement has articulated with existing inequities and vulnerabilities among those whose residence in the UK rely on the EU law. And yet there is limited understanding and awareness of this. And therefore, this webinar foregrounds some of the unheard voices relating to Brexit and citizens' rights, including Zambrano families and children, Roma communities, and EEA citizens with mental health issues, and consider some of the continuities between the hostile environment, Brexit, and how COVID intervened within these. So on that note, it's my pleasure to introduce our first speaker for today. So it's going to be Brian Dickoff. He's a legal organizer at Migrants Organize, the award-winning grassroots platform where migrants, refugees connect, build common ground, organize for dignity and justice for all. Brian coordinates and does casework for the Migrants' Mental Capacity Advocacy Project, and is leading the legal challenge on behalf of EU citizens with mental capacity issues and the lack of provision for them in the EU settlement scheme. Brian, the floor is yours.
Thank you so much, Marie, and thanks so much everyone for inviting me here and having me here today. I'm going to try to share my presentation now. Okay. Right. Can everyone see that? Excellent. All right. As Marie mentioned, my name is Brian. I'm the legal organizer at Migrants Organize, and we're a charity based in London, in Ladbroke Grove. We do two main things. So first of all, we engage in community organizing and campaigns. So we work with different community groups all across the UK, and we also get involved in different campaigns. For example, we are involved with MEDAC in our patient on passport campaign against the NHS overseas charging policy, and we actually recently launched a campaign with These Walls Must Fall against immigration reporting condition called abolish reporting. We also have our community program on the other side, where we offer ongoing holistic support for vulnerable migrants and refugees and asylum seekers who are already in the UK, mainly in Greater London area. So we provide classes and activities, and then we supplement that with advice and casework for immigration, but also a whole host of other welfare issues that arise. So for example, destitution, housing, community care, whatever that turns out essentially. And we also have the mentoring project, which now we've turned into a buddy system since the lockdown. So we have volunteers who call all of our members regularly to make sure that they, we stay in touch with them and offer them emotional support and personal support, which is really important at this time especially. And lastly, we also have a strategic project looking into the issue of mental capacity in the immigration system. So today I'm going to talk about our challenge against the EU settlement scheme, and the fact that at the moment the EU settlement scheme, we believe, is not really accessible to individuals with mental health issues who are unable to, who lack mental capacity to access the scheme. So I guess before I explain about all the issues, I will start at the beginning to explain about what exactly is mental capacity. So mental capacity is different from mental health. It is a legal concept, and you can see the definition under the Mental Capacity Act 2005. So I've put it there in the presentation. Mental capacity in relation to a matter is, basically, mental capacity refers to the ability of an individual to make a particular decision at a specific point in time. So a person is deemed to be able to make a decision if they cannot understand, weigh, or retain any information given to them about that specific decision, or communicate that decision. So if you think about a person who is in a coma, for example, then they kind of lack mental capacity across the board. But mental capacity is, as I mentioned, is decision specific. So when you're talking about mental capacity, you're always talking about a specific decision that the person needs to decide. For example, if you're talking about your elderly parents who needs to decide whether or not they need to go to a care home, for example, that's the specific decision that is relevant. So you can talk about whether your parent has that capacity to make that decision, but the fact that he or she might not be able to make that decision does not mean that he or she lack capacity in other areas of life. And indeed, if you look at the Mental Capacity Act, this idea that a person needs to be able to be author of their own life is heavily emphasized in the legislation. So these are all 5 main fundamental principles of the Mental Capacity Act. And as you can see there, mental capacity has always to be assumed. All practicable steps need to be provided to help someone regain their capacity. So for example, if you're really drunk and you're under the influence of drug, for example, you might lack mental capacity to make certain decisions. But instead of then saying that and disallowing you from make decisions, it's important for us to kind of wait for people to sober up, for example, to be able to make those decisions. A person is also not to be treated as unable to make decision because he would make unwise decision. And if the person does lack capacity, then another person who's making decisions on behalf of that person needs to do it in their best interest. So the question then is, what happens when a person lacks mental capacity to make an application to the EU settlement scheme? As mentioned, we might have people in care homes, for example, who suffer from dementia and therefore doesn't understand what EU is even, or what is the Home Office, what is the settlement application, pre-settlement application. Some people might lack the capacity to understand all these concepts and therefore make an application. And the important question here then is, what happens to them? Because on the 30th of June, after the deadline, if you fail to make regularize your status through the EU settlement scheme, then you're going to be an overstayer and lose all access to all of your rights and entitlement to stay in the UK. Now, I think it's important for us when we think about the impact of, when we think about answering this question, then we need to think about the hostile environment policy in general and how migrants, we're talking about migrants who need to access the EU settlement scheme within the hostile environment policy. And for the benefits of those here who do not know what the hostile environment policy is, it's basically a set of legislations and policies introduced by the government, as the name suggests, to make the UK as hostile of a place as possible for migrants and asylum seekers who want to come to the UK, but also who are already in the UK. So the idea is that people don't come to the UK, and those who are already in the UK would want to be, would want to leave the UK because of these policies. And there isn't just one policy; it's a combination of a lot of different policies and legislations. And the total impact of this policy, I think one of the main significant impact is really what I like to call the othering effect. Because of hostile environment policies, migrants are often really isolated. They can't go to the police, for example, because there's a lot of data sharing happening between the police and the Home Office. They can't get married, they can't open a bank account. Access to education are often restricted, they can't rent, they can't go to local authorities to obtain help from either housing department or community care, they can't go to the hospital, they can't get driving license, and then to all of this, then you have to think about legal aid cuts, for example, where migrants can't really seek help from solicitors because a lot of good legal aid solicitors are always overstretched, and same goes with charities who help migrants. There are always so many people out there that needs help, and we always do not have enough capacity. And then there's the indefinite detention system. So really, when you're an overstayer in the UK, in the hostile environment, you really need to have that strength and persistence in yourself to advocate for yourself, to get out of this hostile environment and prove that you have the right to stay in the UK. And I think that is really the main problem when we're talking about individuals who have mental health issues and lack capacity, because of their mental health and disability, they lack that ability to advocate for themselves. And it becomes really difficult for someone like that to be in the hostile environment and to be able to get out of it. So this is actually an example of one of our members who we've been trying to help. And it kind of gives a sense of how this issue of mental capacity can, provide a really tough barrier to overcome in terms of accessing the EU settlement scheme. So AA is a Portuguese national who arrived in the UK in 2000. He worked until around 2016, and then he suffered an injury and could not work anymore. He told us that his benefits were then stopped. He wasn't sure why, and then he started relying on charitable support and became street homeless until around April 2020, when he was given accommodation at an emergency COVID-19 hotel. He presents with mental health problems and possible learning difficulties, although this has never been diagnosed, and it is extremely difficult to communicate with him effectively. Basically, he doesn't remember much when you ask him. He gets a bit confused. He said, for example, he told us that he might have applied for the EU settlement scheme, but he doesn't have his email address and he doesn't have the application reference number. He said someone helped him, but he can't give us the name of that person. He said he can't remember. He doesn't know whether that person is a regulated immigration advisor, or whether it was just a friend, whether it was a social worker or not, and he doesn't have any more contact with that person. So someone like him, for example, it's very easy, you can imagine that someone like him might just slip through the crack and think, oh, I have applied for the EU settlement scheme, there's nothing else that I need to do, and kind of continue on living. And then after the 30th of June, they will lose all their entitlements and rights to stay in the UK, and really then become, and then it becomes even more difficult for him to obtain help because of all the reasons that I mentioned before. So what is the UK, the Home Office and the government's response to this? This is a screenshot of the policy, the only available policy that mentions mental capacity until around November last year. So up until November last year, the only policy on EU settlement scheme which mentions this issue of mental capacity is the guidance that the Home Office produced for local authorities, and it is, how many paragraphs is that? 4 paragraphs long to address this really complicated issue. And essentially, to summarize, their approach is just to say to local authorities that it is their duty to help people who lack mental capacity to access the scheme. But of course, it's unclear on what duty, for example, the local authority is supposed to step in, with what money, with what financial resources. And as you can see there as well, there's not a lot of thoughts and attention given to this issue at all. It just assumes, for example, for someone who lacks mental capacity and has appointed someone, a lasting power of attorney or a deputy, then that person can apply on behalf of that person, which is great. But at the same time, the issue that I mentioned before is that a lot of individuals we're concerned with are those who are really isolated and wouldn't really have people who are already appointed and all set up to help them when needed. And the government doesn't have any safeguard and any backup plan for these individuals, essentially. Because of our legal correspondence, they have now produced a lengthier guidance for EU settlement scheme caseworkers at the Home Office. I think it's about 2 or 3 pages long. But again, there's still a lot of misconceptions about what mental capacity is, and there's still a lot of issues as well. Because when we're talking about this issue of mental capacity, we need to think about how people who lack mental capacity can access it. But at the same time, we need to think about how can we continue to respect people's ability to make their own decisions. And making an immigration application is a crucial and important decision. And sometimes people might make unwise decisions. They might not want to make this application because of one reason or another. They might think they might be okay just staying in the UK, or they might think they can go back to their country of origin. We don't know. But the point is, people are allowed to make those choices. but at the same time, there's also that need to protect them from the hostile environment policy. So this is the second example. ST is a Polish national who claims to have arrived in the UK in 2007. She is a paranoid schizophrenic with continuous delusional belief, and she's been detained multiple times before and has experienced periods of street homelessness. For the past 2 years, she has been staying in aftercare accommodation provided under the Mental Health Act, and ST refused assistance to regularize her immigration status as she delusionally believed that she has a British passport. She was then referred to us, and we asked them to carry out a formal mental capacity assessment in relation to ST's capacity to make immigration decision. It concluded that she lacked capacity. In January, however, we arranged an appointment, and at that time, she became fully aware of that she needed to apply to the EU settlement scheme, and that the problem she had with doing so was that her Polish passport had expired. As such, and so now we're supporting her to access regulated legal representation to apply to the EU settlement scheme. As I mentioned, mental capacity is also, decision specific, time specific. So at one point, people might lack mental capacity if they're street homeless, for example, without access to GPs or professional help. But once all those things come in, once they are settled in a supported mental health accommodation, they have a support worker and a nurse, they might very well regain this capacity. And so then again, there's this issue of how then do we balance encouraging someone's capacity and respecting their choices, while at the same time, there's a ticking deadline and ticking clock where you need to make this application before the 30th of June. Otherwise, you will lose all your rights and entitlements and be at risk of immigration removal or deportation. So this is the letter that we sent out to the Home Office. They did not reply, but they did produce the extended guidance, which we think are still lacking. So after a series of pre-action protocol correspondence, we have now issued in the High Court, trying to challenge the current lack of system to ensure that people who lack mental capacity are not discriminated against in terms of their ability to access the settlement scheme. We're waiting for permission to be granted. Hopefully it will be granted. And one of the things we're asking them is to extend the deadline and to properly fund local authorities, or provide proper policies on how people who lack mental capacity can access the EU settlement scheme. So just a few last words. I think I want to talk about, what is the main takeaway from this, because today we're talking about hidden impacts of Brexit. And indeed, I think when, it's not just Brexit, when it comes to migrants and in the UK, I think each policy has a lot of hidden impacts, and the only way we can really know the full extent of the impact is really to focus on communities and to kind of direct our attention to those who are, going through the system and living in this hostile environment. And I think it's also important for us to tackle a hostile environment in the same way that it attacks people. So the hostile environment, as I mentioned, is, it attacks migrants from all different directions. You have the police, you have the NHS, you have local authorities. And in that same way, we need to kind of tackle it together, using different expertise and skills at the same time, not just, through legal means or through, advocacy, but also from research, for example, which is always useful when talking about strategic challenges. And that is why Migrants Organize actually recently launched our Fair Immigration Reform Movement Charter to kind of, connect everyone who's working against the hostile environment together to have a concrete set of demands that we want the government to implement. Yes, so if you can please sign the charter and show your solidarity for migrants and refugees in the UK. Thank you.
Thank you so much, Brian, for your talk and also for the work that you do at Migrants Organize, resisting on a daily basis the hostile environment policy. And I'm sure there will be quite a lot of questions about your work and campaign later in the Q&A session, and how people maybe can perhaps support Migrant Organize in their advocacy work. So let me introduce the second and third speakers for today. So we are going to listen to Claudia Bernard and Iola Salenke, and they will be both speaking on the impact of the hostile environment and the Zambrano carers and their residency rights and other things as well. So Professor Claudia Bernard is a professor of social work and co-head of the Department of Social, Therapeutic and Community Studies at Goldsmiths, University of London. Her research interests lie in the areas of social work with children and families, gender-based violence, critical race theory, equalities, and social justice. She has written widely on these topics, including a book entitled Constructing Lived Experiences, Representations of Black Mothers in Child Sexual Abuse Discourses, and an edited collection entitled Safeguarding Black Children, Good Practice in Child Protection. She's currently writing a book entitled Intersectionality for Social Workers, Theory and Practice for a Diverse Society, to be published very soon by Routledge. Professor Iola Salenke holds the chair of European Union Law and Social Justice within the University of Leeds Law School. She's a former visiting professor at the Harvard University School of Public Health and Fernand Braudel Fellow at the European University Institute. She's the author of EU Law, Making Anti-Racial Discrimination Law and Discrimination as Stigma, a Theory of Anti-Discrimination Law, as well as many other articles in peer-reviewed journals. She's also the founder of the Black Female Professors Forum, which promotes the visibility and progress of Black women in academia. And she's also currently the PI on a UK research and innovation funded project looking at the impact of two viruses, COVID-19 and discrimination, on practices of well-being and resilience in Black and Asian and minority ethnic families and communities in the UK. So Claudia and Iola, we are very pleased to have both of you today with us, and please, the floor is yours.
Thank you very much, Marie, and thank you to the organisers for inviting us and giving us this space to talk about not only our project, but also our research. So we're going to present in two halves. I'll start by talking about the Zambrano carers and the creation of this right of residence in the European Court of Justice. And then Claudia will say a bit more about in relation to children, specifically in mental health, and the Co-Power project that was just mentioned. So we have some slides, so I'm going to try to share my screen. Right, so my part in talking about the Zambrano carers, the approach I take to Brexit is an intersectional analysis. And I think this is a really powerful analysis to take in terms of understanding Brexit, and especially in relation to highlighting hidden communities, because this approach moves us away from just looking at, UK nationals in the EU and EU nationals in the UK, because there are other groups of people who also relied on European rights in European Union law for their residency. And so with Brexit, they have also lost their right to reside in the UK. And this is a nice link with the previous speaker, because ultimately the group that I'm now going to talk about have to rely upon being given a status under the EU settlement scheme. And that is just as difficult for them as has been explained in the previous presentation. So the specific group that I'm going to talk about are persons who are from outside of the European Union, but have been given a right to reside in the European Union because they are carers to a European Union citizen. So they are either carers to a British national or French or German national who automatically is a European Union citizen. So the other nice aspect of looking at these carers is that it gets us away from just looking at the impact of Brexit on adults, because many of those who are affected by Brexit are also children. So the emphasis in my presentation, or in our presentation even, really is on infant citizens whose parents have lost their right to residence as a result of Brexit. So as I said, the starting point for this whole scenario is a case in European Union law. And this was a case that arose in Belgium, where you had a family from Colombia who had actually not been given asylum in Belgium, but had been allowed to stay in Belgium because they were political refugees from Colombia. During their stay in Belgium, they had children, and because of European Union citizenship rules, those children automatically became European Union citizens. Now, as you will all probably know, as is regularly the case, persons with irregular status in a country often are allowed to work, and that was exactly the situation for Mr. Zambrano. So although he didn't have a regular status, he wasn't removed, he was allowed to stay in Belgium and he was allowed to work. The problem arose when he lost his job, and as he had been paying taxes, he perhaps foolishly assumed that he would have access to unemployment benefit. Well, as soon as he applied for unemployment benefit, the Belgian authorities then wanted to deport him. The case went up to the European Court of Justice, and essentially the Court of Justice said that because of the children who were European Union citizens, the parents, Mr. and Mrs. Zambrano, had to be given a right to reside in Belgium, because if they were deported, obviously they would have to take their children with them. And if their children had to leave the European Union, then they would not be able to enjoy the rights associated with their status as European Union citizens. So the Court of Justice basically said that in order to ensure that these children who were European Union citizens genuinely enjoyed their status as European Union citizens, the Belgian authorities had to give the parents, Mr. and Mrs. Zambrano, a right to reside. Now, this ruling didn't just apply to Belgium, it applied everywhere, including here in the UK. And please note the date. This case was decided in 2009. So a long time before the Brexit referendum and a long time before Brexit, but during the emergence of a raft of policies creating the hostile environment. Now, this fact that non-EU nationals were given a right to reside in the United Kingdom as a result of European Union law, as you can imagine, is one that the then coalition, Conservative Liberal Democrat coalition government, were not pleased by. So what did they do? They immediately introduced legislation to ensure that anybody residing in the UK as a Zambrano carer would not have access to a range of basic welfare benefits. So things such as income support, job seekers allowance, employment allowance, pension credits, council tax benefit, child benefit, and child tax credit, and housing benefit were immediately, access was immediately blocked for anybody residing as a Zambrano carer. And this is despite the fact that many of those residing as Zambrano carers were looking after children who were British citizens. which then of course has an impact on the quality of life of those children. A number of these women were from countries in Africa and the Caribbean. So essentially we are looking at Black British children being forced to live in destitution, because what happened was when the parents were prevented from accessing these benefits, they then had to rely upon emergency assistance from the local authority. So they were put in short-term housing and given minimal financial assistance to feed themselves and their children. Now, these amendments were challenged in the courts, but unfortunately, the courts supported the government. In a case that went to the Supreme Court, HC, the court argued that it was actually within the margin of discretion for the government to impose this prohibition on access to basic benefits for those who had a right of residence in the UK as a result of the Zambrano ruling. So what this essentially meant is that the hostile environment that was created for migrants became a hostile environment for Black British children who were being cared for by those non-European Union migrants. The only person in the Supreme Court who identified a problem with this, this rule in sanctioning the Zambrano amendments was Lady Hale, the last president, the former president of the Supreme Court. And what she said was that this was the HC case was a very troubling case, because essentially her colleagues had approached it as a case about adults' rights, but actually it was a case about children's rights. And as she said, specifically the right of two very young British children to remain living in their own country and to have the support which they need in order to enable them to do so. And she went on, self-evidently, they need the support of their mother in the shape of the care which she is able to give them. But they also need support in the shape of a place to live and enough to live on. And of course, these Zambrano amendments meant that their parents, predominantly women, had neither of these things. So the hostile environment has implications, especially during the COVID pandemic. When we were introduced, the project that I'm currently leading with a team of eminent Black female professors across the United Kingdom was mentioned. And this project is all about looking at the practices of well-being and resilience by Black, Asian and minority ethnic families and communities in the United Kingdom. And one group that we particularly want to focus on are those children and families who do not have recourse to public funding over COVID-19. So we really want to know how they are surviving. It was hard enough before the pandemic, so it's hard to imagine what resources they've been able to rely upon now that we are in a pandemic. And I'm now going to hand over to my colleague Claudia to talk more about this aspect of the project.
Thank you very much. So as Iola has said in introducing this, we are very aware that the pandemic has exposed and amplified existing structural inequalities, and in particular, pre-existing race biases within our society. And the pandemic presents issues that could have long-term effects on the mental health of diverse groups of Black and ethnic minority children and young people. And we already know from some of the data that's been gathered that Black and ethnic minority children and young people have distinct experiences and face a range of compounding inequalities even before the pandemic started. And Iola has set out what some of those are already within the EU context. And these groups of children and young people are caught at the intersection of the pandemic and long-standing racial inequalities. And we are particularly aware that the ramifications of the COVID-19 pandemic are much more severe for certain groups of vulnerable children, and unaccompanied minors are a particular vulnerable group. And we are acutely aware that migrant and displaced children's lives are already marked by insecurity and will be affected even more seriously by the socioeconomic effects of COVID-19, because we know that particularly groups of Black and ethnic minority people are much more likely to be vulnerable in terms of being affected by COVID-19, are much more likely to die, are much more likely to be working at the front line. So there are a range of intersecting factors that contributes to Black children and young people's experiences. And we are particularly interested in exposing the diversity and the nuances around particular groups of children, particularly those groups of children affected by Zambrano, and the sort of hidden nature of some groups of Black children's experiences. And so therefore the core power, the consortium on practices of well-being in Black and ethnic minority families and communities will inquire into the unequal effects of the pandemic on resilience and well-being. What does resilience mean for those groups of children? What does well-being mean for those groups of children who are really on the margins of our society? And they're on the margins of society. They're an underserved group, and they're an underrepresented group when we think about migrants and the diversity of migrants and their particular experiences. And in the research that we will be doing, we're wanting to look at specifically and dive down into looking at how does systems of injustice and inequality, how do they impact different groups of children, but in particular, how do they impact these groups of children who are affected in a particular way? And that is what we are, the research project will be looking at. The project has only just started in February. It's an 18-month project, and we will be keen to really engage with organizations that work with groups of migrant and displaced children, because those are the groups of children that are often hidden away. And we hear very little about the effects of COVID on them in the UK context. And we really wanted to engage with the issues for these groups of children and young people, to make visible what the particular issues are for these groups of young people, because we know that COVID-19 is and will have a particularly huge impact on the next generation of Black children and young people. So we need to kind of really be getting to expose some of the issues and some of the factors that needs to be considered in terms of policy and the legal context in relation to these groups of children. So that's what, briefly, what we'll be wanting to do within the CoPower consortium and the research that we're just starting. So I'll pause there, and maybe there'll be an opportunity when we get into the discussion to have more questions, and we can say a little bit more.
Yes, yeah, thank you both. Yes, for sharing with us your research. So I clearly learned a lot about the EU settlement scheme and the issue related to Zambrano families, and it fulfills so well the aim of the overall webinar, which is to challenge dominant narratives on Brexit and EU citizens. And also thank you so much for having shared with us this new project entitled Core Power. So we are really looking forward to know more about it. So I'm going to introduce the last speaker for today. So Mihai Kalin Bisa. So he's in charge of the, he's part of the Roma support group and in charge of the Roma Brexit campaigning and policy project at the Roma support group. So the Roma support group is a community-led London-based charity set up in 1998 to help Eastern European Roma settle in the UK. Mihai has a professional background working around human rights of those from the Roma communities in Romania and not only. And he's currently doing policy and campaigning work, leading the work on Brexit and the EU settlement scheme. So Mihai.
Thank you very much, everyone. It's a pleasure to be here this evening, and it was great to listen to all the other speakers, and I've learned a lot from their experiences as well. And I hope what I'm about to share about those from the Roma communities will be interesting to hear from you as well. I will I will say a few words about Roma support group and about the Roma communities in the UK. We are the first and the biggest Roma charity in the UK, as Marie mentioned, set up in 1998 to support Roma settling in the UK. We're mainly an advice and support charity, but most recently we started doing some campaigning and policy related work in various areas. We deliver a wide range of projects, including providing advice and assistance directly to those from the Roma communities in London, and not only, but also working with professionals in different areas, such as local authorities, education, university, schools, and so on, supporting them in their own work with those from the Roma communities, as well as providing trainings and sort of different areas regarding working with those from the Roma communities. The Roma community here in the UK is quite a diverse one. I have to mention that the first waves of Roma came here after the fall of the communist bloc in Eastern Europe. This means that we have quite a significant Roma community in the UK coming from the Eastern European countries, but not only. We are aware of Roma from South American countries, from African countries, and from the other continents as well, living in the UK. But vast majority of those whom we work with directly are from countries like Poland, Romania, Slovakia, and other Eastern European countries. We are talking about a community who unfortunately has quite a negative historical background, a community who was targeted, who was a victim of negative behavior coming from public authorities in the past, including a community who was enslaved in the Eastern European region for about 500 years, was targeted by the Nazi regime, and so on. And I'm mentioning here because it has strong relations with in the context of Brexit, because this had a direct influence on people's abilities to go through education, to acquire skills necessary to successfully go through a process such as Brexit. This means that there are low levels of education among those from the Roma communities, including high levels of illiteracy. Recent research shows us that about 20% of those from Roma communities self-declare as illiterate in the European Union, comparing to 1% in the sort of wider population. This obviously has a strong influence on people's ability to go through an online digital, through an online process. Now, in regards to the hostile environment, I have to say that we have seen that impacting those from the Roma communities way before we started talking about Brexit and these sort of issues. We are going back to what happened in 2004 and a little bit before that. I've mentioned that most Roma started coming to the UK before, after the fall of the communist bloc, and before many Eastern European countries have joined the EU. And at the time, people from the Roma communities were coming here as asylum seekers, and they were granted, based on that, granted indefinite leave to remain. Now, in 2004, when several Eastern European countries joined the EU, we have seen the impact of sort of hostile migration policies from the UK government against those from the Roma communities, when nearly 2,800 families who came to the UK from now newly European Union countries through the asylum seeking process. When the Home Office informed them that in 2 weeks' time their asylum seeking status will no longer be recognized, and they have two options: either seek employment and become legally under the new status, the EU citizen, or leave the country. And that has obviously a huge impact on those families. We are aware that there were about 2,800 families in this situation, vast majority of whom were Roma families. Luckily, there were some right people in place, and we've managed to challenge those policies and help those families remain in the UK. But we were at the brink of closing down the charity because of the huge sort of request of support that we had in April 2004, when we literally helped more than 500 families individually submit appeals against those decisions. We continue to see the impact of obviously the hostile sort of attitudes, policies, environment against those from the Roma communities, especially with against those from those sleeping rough, whom were targeted by these policies, who were deported for a number of years. We've seen these policies against informal workers, such as those waiting in front of a B&Q to be picked up for work, and so on. That has obviously continued throughout the Brexit process and throughout the USS process, when we have seen these people being concerned, afraid to make applications, thinking that they are actually targeted by the government, who is only intending to seek information about them and to deport them, who has absolutely no positive intentions regarding them. and this has made us really difficult for us to be able to help these people make applications for the EU settlement scheme. We have also seen them and not only these categories having difficulties obtaining evidence to make EUSS applications. In regards of how the process has been working for those from the Roma communities, we have published a report back in June last year, where we gathered information on how the EUSS is working for those from the Roma communities across the UK. And that information was collected up to March 2020. And we have seen that there was at that time a limited support available, and even more than that, limited reach to those from the Roma communities. This was because there are very few Roma organizations in the UK and very few Roma advocates who have connections with the community, and even more, we have seen extremely limited experience of working with Roma people widely in the charity sector, and this has had a strong impact on capacity and ability of organizations to reach out to those Roma communities and provide support. We have seen that anywhere from 15 to 25% of Roma, including children, are still not aware of EUSS and still have to make applications. We have seen majority of those living rough, not making applications because of all the concerns that I have mentioned earlier. In regards of how the situation will look like soon, we have some concerns, especially in regards to the children. And we see now that a majority of the parents that we get in touch with are asking us about their children and what they have to do, as they are not aware that children have to make applications as well, including some of those who are born here in the UK. Vast majority of the parents who have children born in the UK believe that their children should not make EUSS applications. We also see professionals working with children, such as those in the education environment or social workers, not being aware that children have to make applications, not being aware of support available, or where to signpost families for information and support, and so on. We are now seeing a potential windrush in the making in the case of Roma that came here as asylum seekers after the fall of the communist bloc. We are now seeing dependents of those people having difficulties proving their status at the moment. These people believe that they should not make EUSS applications, as they believe that they have ELR status. But from practice, we are already seeing cases where these people have their status basically challenged when they are making applications for universal credit or housing benefit and so on. We are already seeing cases of people being refused access to this support based on the status as an ELR dependent. We are seeing some problems coming up soon with these people when they will no longer be able to rely on their EU citizen status or their ELR dependent status either. And we, from our discussions with them, we see that they don't know what they have to do to either clarify their ELR status or either make EUSS applications. We are seeing huge implications coming from the fact that people have to rely on the digital only status that the EU settlement scheme has. So everyone is expected to use a digital only status. As of 1st of July this year, after the deadline of the EU settlement scheme, people are actually not receiving a physical evidence of their status, and they are expected to be able to log in online and access the status and prove it to whomever they have to do so. In the case of Roma, we see that nearly 80% of the people that we work directly with are not aware of how to access their status, how to use it, or even are not aware of its existence. And many are lacking the details needed to access this digital status. So we see that this will be a huge problem coming up soon. We already see cases of people having difficulties because of that. For example, after the pandemic started and the government asked everyone to make universal credit applications, we've seen people trying to do that and not being able to complete their applications because the DWP was asking people to share their EUSS digital status details with the DWP, and people were simply not able to do that, and they had their applications refused because of that. And we are already seeing employers asking people of this status when they actually shouldn't do this yet, but some of them have already started that. And we are seeing a problem that children in care might have soon, as we see there is a lack of support, lack of information available in that area. So I know I've already gone over my time, so I will close here and obviously welcome any questions. So thanks very much.
Okay, thank you to all of our speakers for those really fantastic presentations, shining light on such a range of issues that I think, you know, many of those in the audience will be aware of, I suspect, but might not have, but don't necessarily see all together in one place presented so publicly. And I just wanted to say a few words before I draw out some of the questions that have come in over the course of the presentations. And please do carry on putting your questions into the chat, and I will try to keep on top of them as we move forward into the final part of the evening. I wanted to thank our speakers for really drawing out so clearly how some of the inequalities and injustices that have been exposed by Brexit and by COVID have a much longer history to them. And really, I think that all of our speakers have shown incredibly well how this sits in respect to that much longer hostile environment that's been building up over the last few decades in the UK. But I also think that they've shown really clearly not only, you know, how those kind of institutional structures, how that those emerging systems through the EU settlement scheme have kind of compounded and exacerbated those inequalities, and in some cases just actually completely overlooked some of the people whose rights are being transformed by Brexit. But they've also shown the real human impact on this and the kind of generation in action of these inequalities. So I think that that's really important for us to hold in mind, both in terms of the past and in terms of what's happening now. Now, I know that there's a whole series of questions that have been coming in over the course of the presentations. So I think that I'm just going to launch straight into that. And I'm going to ask our speakers to join us all. And I'm going to ask, first of all, I mean, there are a couple of general questions that have come in that I think cut across all of the speakers. And I think, you know, people are very concerned about the kind of number of cases that, the number of people that this might impact on. And I know that this is like a question which is, you know, how long is a piece of string? But I'm just wondering whether, who is documenting all of this? Who's documenting the number of cases relating to kind of mental incapacity? who's documented the kind of fallout, I suppose, because as we know, those kind of statistics speak quite loudly in that general thing. And how do we keep an eye on it, I suppose? So I wanted to ask the panelists for any thoughts on that. Brian, do you want to come in?
So I guess in terms of people who lack mental capacity, that's actually one of one of the most significant issues with this issue. We're talking about EU citizens who lack mental capacity, but also the same issue also applies in the wider asylum system, for example, and for victims of trafficking, what if they lack mental capacity to get referred to the national referral mechanism, for example. And indeed, there is a lack of data around this issue. And, as someone who works in the field, that this is happening because of all the trauma that the people that we work with goes through on a daily basis, in their journey into the UK and in the UK because of hostile environment. And an obvious corollary of that is that they will suffer from mental health issues, which then might affect their mental capacity. But obviously, these are all not self-evident, especially if you're talking about, proving to the Home Office or proving to the court that this is an issue that is happening. And yeah, so part of the strategy of our project is actually to kind of start building evidence of this issue. But obviously we have quite a few qualitative evidence. So we have 50 cases at the moment, for example, but quantitative data is really difficult to find, especially when, the governing body, when the Home Office themselves, so we understand what mental capacity is, how to spot the lack of mental capacity, and definitely is not kind of collecting all this data. Yeah, so that is the challenge essentially.
Yeah.
So I can say something in relation to the Zambrano carers on that. Initially, the Home Office did have some data, and it did publicise some data, which is how I could identify that the majority of the of people who were resident under this status were female, and were predominantly from Nigeria, Ghana, and Jamaica. But because the responsibility really has been devolved to the local authority, I think now most of the data resides with the local authorities. And I don't know how carefully and assiduously they are collecting it. There is also an organisation called, which specifically focuses on those with no recourse to public funding. So I think they might also have some data, but it's unclear, and I suspect it's very fragmented and very incomplete. And in terms of the numbers who are applying for the EU settled status, there are some numbers coming through, but I'm not sure how reliable they are.
That's really helpful, thank you. Mihai, do you have anything to add there?
It's very difficult to assess this sort of issue. We know that the Home Office is not recording data on ethnicities, and therefore they're not doing that regarding those from the Roma communities. And it's very difficult to assess how many of those from Roma communities have applied already. We have done an exercise by directly asking organizations whom we are in contact with of how many people have they supported. But still, if we go by that, we see that it's quite a limited number of people who have been who have made applications. We don't know how many have made that independently without support. So this is something that we are trying to influence the Home Office to do something about, as well as this will definitely help us then develop further work to ensure that as many people as possible successfully go through the scheme. But so far this work proves to be quite difficult.
I mean, I think it's really telling that in all cases there are problems with accessing that data on a larger scale, and it's being left to kind of grassroots and advocacy groups to actually generate the evidence that you would you would hope that the government might collect, but we also know that the decision to collect particular forms of statistics and make them visible is entirely political. So I think that's kind of an important thing to bear in mind. But yeah, I mean, lots of people are very, very concerned about the impact of all of this on mental health, which I think you've all shown quite clearly through your projects, through your presentations this evening. And there is a series of kind of quite specific questions around this, which are to do with the kind of framing of this. So there's a question that's come in which talks about that kind of relationship with thinking about well-being and resilience, and what this does to our understandings of, you know, who really needs to take kind of responsibility for this. And the question specifically is that, you know, by kind of turning onto kind of questions of resilience, does this burden migrants further by making it seem like they're the problem, that they're weak and incapable, instead of kind of addressing the external discriminatory practices that make their life difficult? So I suppose this is about the kind of conceptual framing of those problems. And again, I think this is open to the whole panel, if anybody wants to come in on that.
Claudia, did you want to come in on that, or should I?
Yes, I did. I can't, I'm not so au fait with Zoom. I can't find the hand that you put up. I'm a Teams person. Could I come in and make some comments about that?
Yeah, that would be great.
We've been thinking a lot about that, you know, the sort of different models and definitions of well-being and resilience. And we know that resilience, particularly with Black and ethnic minority communities, there's often a sense that, well, they're strong and they can cope and they, you know, they can get on with it. So therefore we don't have to put in any interventions or any support. And we're using a model of cultural wealth model, because we really want to try and capture how do individuals understand resilience, and how do they understand their own emotional and resources to thrive and survive in very hostile environments. So, and how do we work with communities and with groups to actually access children and young people who can also tell us how they interpret their experiences. So for us, it's very important to come with a model or some ideas about well-being and resilience that's starting from a strengths perspective and located within a social justice context, and can embrace the sort of a lot of the intersectionality factors that contributes to lived experiences. So those are some of the thinking that's informing the approach we'll be coming at it from, to actually engage with, well, what does well-being mean for these particular groups of children and young people? How do they understand it? Moving away from this idea is that these are people you go in and you do to them, and they need fixing, rather than the structural context and the structural inequalities, as has been said before, has compounded and exacerbated the kind of inequalities that they'd experienced anyway. So I think it's a very important question to ask, and that's why I think for us, working with the agencies that have a good intersectional understanding of these issues will be really important for us in the research that we're trying to do.
So really starting with the people that are taking part, who you're working with in the research, and asking them the questions of what these things mean to them, rather than imposing your own.
Exactly. And it really is, what we really want to do is actually hear from people themselves. So this isn't about taking a framework and imposing it and trying to fit people into it, but we really want to hear from the voices of people. What is happening to them? How are they coping with the terrible circumstances we're all living with, in addition to the terrible circumstances they were already living under? And it's not just about what they do, it's also about what structures they are having to cope within, such as, you know, the Zambrano amendments, such as the European Union settlement scheme. So we don't think about well-being and resilience as individual concepts, but for us they are very much about self, society, and community and structures.
It's really great, thank you. I think that's really clarified that set of points. And Mihai, Brian, did you have anything to add to that conversation? I can move on to some more questions. So, yeah, I mean, I think there's also like there's a set of questions here relating to the individual papers. So I'm just going to channel some of them specifically. So I'll start with a question for Brian, because I think people wanted to understand a little bit more about who makes a decision about whether one has or doesn't have mental capacity, who has that authority. And then if somebody's working on your behalf, what, you know, do they have to, do they do a paper application or is it digital? I mean, these are very practical questions.
Yeah. So under the Mental Capacity Act, technically anyone is allowed and in fact encouraged to assess capacity. So if you look through the Act and the legislations and the accompanying code of practice, the Mental Capacity Act was very much enacted to kind of, you know, with the care context in mind. We're talking about, you know, most of the time elderly individuals in care homes suffering from dementia, for example. What can us as a society do to help these individuals, for example? So under the Act, it actually empowers people like carers and nurses to make decisions on behalf of these individuals when their health fluctuates, when they're having bad days and they can't make decisions about their care, for example. It actually allows people to just make decisions on their behalf immediately, as long as they follow all the principles that I mentioned before under the Mental Capacity Act. But of course, then at the moment, we're talking about translating all those principles into the immigration context, where the relationship between the government and the, you know, migrants are really different from, you know, the government and people in care homes. Because when it comes to migrants, you have the hostile environment and, you know, the position is really very much adversarial. Sorry, where was I? Kind of losing my train of thoughts now. So in terms of who can assess mental capacity, technically anyone can do it. But I think someone mentioned in the chat box as well, most of the time it is medical professionals who are expected to do it. But the tricky bit is, again, because it is decision specific, you need to be able to assess mental capacity in terms of going through the immigration process. And then if we talk to GP, for example, a lot of them don't really know about, you know, how to make application or what exactly a solicitor does or what is an appeal, for example. So it's really hard to be able to assess capacity without knowing the context of the decision. But at the same time, the Home Office doesn't really have a clear policy on this. And in other areas of immigration, there's often a great reliance on medical assessment and medical professionals doing assessments. So they don't really trust when support workers or social workers make an assessment, for example. They want psychiatrists or psychologists. So then that's also another question. It's like if someone lacks mental capacity to make an application, will it suffice for the Home Office, you know, to accept evidence of lack of capacity from just support workers? And should that be the case, is that enough safeguard to ensure that people are not deprived of their ability to make decisions prematurely, for example? So one of the main issues is actually who can make an application on behalf of someone who lacks mental capacity, and where does that person derive authority from? So, you know, you can't just make application on behalf of someone without, you know, without any supervision, for example. At the moment, what we do is we make an application to the Court of Protection, which is a specialized court set up specifically to deal with mental capacity matters. And we ask the court to appoint someone to allow them to make this decision on behalf of that person who lacks financial capacity to access the EU settlement scheme. But obviously that adds to a lot of delays and a lot of processes as well. And yeah, so that's kind of the issue. Once that person is appointed, then I guess it doesn't really matter whether it's a paper application or an electronic one. I'm guessing it's probably going to be a paper application, because then you have to explain why you're making an application on behalf of someone.
That's really helpful, thank you. I think it also highlights one of those other dimensions that I think came across quite clearly in the other, well, that some people have been raising questions about, which is to do with kind of other intermediaries and other agencies that might be involved in all of these processes. So one of the questions that's come in is to do with what support statutory agencies like Children's Services Support might provide in the case of, I guess, like the Zambrano families, or in the case of the Roma communities, because Miha, you talked quite extensively about children there as well. So I just wondered if you had any thoughts on that, Iola, Claudia and Mihai.
So from what I know about the Zambrano carers, when they have been forced to go to local authorities, they've had to rely on emergency care provided under the Children's Act. So the care is provided to the parent for the child, for looking after the child. But that is very limited. It's limited in terms of cash, and it's limited in terms of the type of housing that is available. So the families are generally put in short stay accommodation, and might have to go from one short stay accommodation to the other. So the local authorities are having to deal with this issue, but I think they're doing so quite unwillingly, because the budgets are already strained, and they resent the being forced by the central government to take responsibility for these families. But they do so, but the assistance is minimal. Beyond statutory authorities, and as I mentioned, there are some grassroots organisations that will try to provide some help, but it's all quite fragmented and very unsatisfactory.
Claudia?
I just wanted to come in and add, in terms of thinking about children's services, I'm just wondering how aware, in terms of the Zambrano, I'm wondering how aware practitioners and managers are aware of that group of children within that. Because in terms of looking a lot of what's written, a lot of the research into, there is quite a lot on unaccompanied minors, but I haven't seen a great deal about that particular group of children. And I'm just wondering about awareness and knowledge really there.
I think that's a very important point. Yeah, Mihai, did you want to come in on that question as well?
From our experience, we see that basically professionals working with children in education environment, or on the social services environment, are still lacking information around the Brexit process and the EU settlement scheme, and this is the main problem that we see in this area. Although recently the government has developed guidance and published information regarding children, specifically children in care, we still see professionals in this area not being aware of the regulations, of the ESS situation, the requirements, and so on. Furthermore, they're not aware of where support is available and how to facilitate support for these children. We see some improvements. We know of cases where social workers, for example, are doing good work, but at the same time, we still see people who are not aware of this. And the same goes for the schools and people working in the education environment. Unfortunately, a huge amount of time has already been lost where great work could have been done in school to provide information to parents, to provide information to children, and to provide support as well. Although there was a lot of support available from organizations who had home office funding, great opportunities have been missed because the schools were not aware of these requirements. And furthermore, the Home Office has not done a lot of work to ensure that information reaches out to children specifically. And there is still, materials are still expected to be released even now when there is such a small time left until the deadline.
It's a very depressing picture that's emerging here, and even in the chat, some of there's even more kind of information that kind of confirms this kind of lack of resource, a lack of response, and the way in which children are really not being accounted for in this process at all. Now, there's a question that's come in, Iola, that I think is probably specific to you, which is to do with the fact that the majority of Zambrano carers that have applied to stay in the UK under the EU settlement scheme have been rejected. But the question from Agnieszka, who's written this in the chat, is whether you are aware of any who've been successful, and whether, now that they have settled status, they might be eligible for public funds.
Thank you for the question. So the access to settled status is intended as the alternative to access to EU law, so the status under EU law. So as with the Zambrano case, all that settled status does is provide a right to remain and not to be deported. It doesn't, as far as I'm aware, go any further and provide an additional right to access to those basic benefits that have been withdrawn by the Zambrano amendments. That's precisely what the Supreme Court said. The government is only required to provide residence. The government is required to ensure that the family, the EU citizen, can remain in Britain. The government is not required to guarantee any particular level of standard of life for the family. So the EU settled status doesn't change that. So that it remains, they can stay, but they will remain reliant upon local authority emergency funding.
So there's I'm going to say there's no joy anywhere with that. So, which is an understatement, I realise. Yeah. So, yeah, and I mean, there's another question as well that is specifically about children. There are lots of questions coming in about children. But it's a question that's come from Don Flynn, who asks that in addition to the Zambrano families, there's also the case of the Baumbas children who are not EU citizens, but have been allowed to remain, if I understand correctly, with non-EU parents until they've completed their education. And his question is there any indication of how the Home Office will regard that case, the case of these families, when the children complete their education? And it ties in with an earlier question that we received, which was to do with the question of the parents of the Zambrano children, and whether their parents will be at risk of deportation once their children reach adulthood.
Is that one for me as well?
I think that's one for you, yes.
So the answer to the first part of the question is I'm not sure. So the parents have been allowed to stay because of the rights of the children. In the Zambrano case, what might happen is that because these are British citizens, it might then be that the parents are allowed to stay because they are now dependent upon the children for their well-being, for their livelihood, etc. I'm not aware of that question actually coming up yet. It's just a bit too early, but of course, it might be that the government says, well, now the child is of age, can live independently, therefore there is no compulsion for the child to leave the European Union, therefore there's no need for the parent to stay. That is not unimaginable. In relation to the bound-bass scenario, where you have children who are allowed to stay because of the parents, again, I'm sorry, Don, I don't have a clear answer for you there either. But again, if the reason for the permission to remain has been removed, then it wouldn't be a surprise if the government then said, well, now your right to reside has expired and you must leave.
Thank you very much.
I'm sorry, I'm really not giving any positive answers this evening, but it's just.
Well, I don't think I don't think that when we set up an event on kind of these more long-standing inequalities and injustices, we thought that there would be any positive takeaways for this evening. I think it's really important that we have shown that some of the issues that probably haven't received quite as much attention as they should have done over the last few years. And it's important that we continue to actually pay attention to those and the long tail of them. I mean, that's the kind of conclusion of where I've got to with thinking about those issues. You know, there will be consequences and knock-on effects for years and years to come, because these are incredibly, what people's lives are, what they are. They go on for a long time. So I think that that's a really important thing to bear in mind. And I'd just like to say thank you to all of you, you know, for what has been a really cohesive set of papers around a set of very challenging issues that we all need to think with, that Brexit and COVID have raised for us, but also how they sit within that hostile environment. So I think that the takeaway story from all of you is that this is more of the same. It's more of what we've been, you know, what we've become used to for those of us working on the hostile environment for long periods of time. And we need to continue to pay attention to it and to recognise those inequalities, those racial inequalities and injustices that are at the core of migration policies in Britain today and the various exclusions that they build up. So thank you all very much.